Good evening, and welcome to the Township of South Orange Village Planning Board regular meeting for Monday, July 7th, 2014. Jetta, can I ask you to read the roll, please?
Yes, Mr. Colton-Max.
Here.
Mr. Miller.
Here.
Reverend Wilson.
Here.
Mr. Allen.
Yes.
Mr. Chambers.
Here.
Mr. Lerman.
Here.
And Ms. Harris.
Here.
Pursuant to Section 5, Chapter 231, PL 1975, this is to state for the record that adequate notice of this meeting has been provided to the public by posting and maintaining the annual notice of regular meetings on the bulletin board in Village Hall, by mailing the annual notice of regular meetings for 2014 to the South Orange Maplewood News Record and the Star Ledger in December 2013, and by filing said notice in the office of the village clerk. I just want to check that all my fellow members have a copy of this evening's agenda in front of them.
Yes, we do.
Okay, so having said that, we'll move on with the first item, approval of resolution, case number 236, Papillon 25 Restaurant LLC, Block 1906, Lot 6, 24 First Street, minor site plan. The applicant is proposing to operate the property as a restaurant and sports bar. The resolution was sent out a few hours ago via email. Have members received that?
Yes.
Okay, then, that being the case, I'll entertain any discussion or a motion.
I'll move it.
Okay, you move
Second.
approval of the resolution as submitted?
Second.
Okay, and second from Reverend Wilson. Okay, you want to do a roll?
Well, just before, I haven't seen it.
Oh,
so-
I'm sorry.
It came, if it went out this, today, I haven't had a chance to look at
It
it.
went out about 4 o'clock, I got it.
Yeah, I haven't had a chance to look at it.
Would you like us to withhold voting on this for the moment, and then you have an opportunity to review it to vote later? Or would you just assume we go ahead and hold the vote, and if you choose to abstain?
I'm gonna have to abstain because I have no idea what I'm voting on.
Do the other members feel as though they have, I mean, I know it was late getting to you, but did people feel as though they're prepared to vote? I mean, if not, we'll hold off until later and take a few minutes before doing it.
I think it's fair to hold it off and let all members of the board be able to have a chance to read it so that they can weigh in.
Okay, so what we'll do then is, can I just ask a question? Is the resolution in hard copy here this evening?
Here it is.
Okay,
I brought a copy.
okay. So I'm going to pass that around.
And there's another one here, if somebody else
Okay.
wants to.
Okay. Does anybody else want a copy of a hard copy of the resolution? No? Okay. I'll tell you what, do you want to just are you taking a moment to look through it now?
I'm doing that right now. I mean, not to slow down the process, I mean, if everyone here feels like they've looked at it and they are gonna vote in the positive or the affirmative or whatever.
That was fine.
I mean, you should take the vote because if, you know,
Neil, all I
slow
can
it.
tell you is I've read it. It encompasses everything that we've talked about. Obviously, also the videotape is really backs it up. I mean, it doesn't have the comments such as parking and stuff like that, where reluctantly, we went forward with it even though there was not enough parking. But it does detail.
There is mention about parking.
Yeah,
There's mention about
minor,
it.
minor. But it does detail everything that we agreed on and voted on,
Okay.
from my point of view.
so I'm saying that no, if you guys feel comfortable and, I'll let the vote go and if it doesn't pass, then I'll have time to review, but I'm not
Okay.
gonna slow it down.
Okay, so then let's proceed with the vote by roll call. Jetta, please. Is that okay, Reverend Wilson?
Of course.
Okay.
Okay, Mr. Colton-Max.
Yes.
Mr. Miller.
Yes.
Mr. Chambers.
I can abstain.
You can abstain.
I'll abstain.
Reverend Wilson.
Yes.
Mr. Lerman.
Yes.
And Ms. Harris.
Yes.
You're not eligible to vote since you voted against the resolution.
Thank you for explaining the rules.
So, thank you. And so that motion, that resolution is passed. Now we're moving on to...
Mr. Chair,
Yes.
before we leave that, I just want to, again, address the parking issue. I happened to be sitting in that restaurant the week it opened, and the traffic in the parking lot at about between 6:30 and 7:30 at night was a nightmare. I mean, why there weren't accidents is a miracle. So I just wanted to,
Can't be
Papillon. Papillon's been around for a very long time.
not Papillon, I'm talking of Rickleton's.
Rickleton.
Rickleton's.
This is for the old Cryans, though.
Yeah, I know, but I understand.
He didn't
that.
mean this restaurant. He
I'm
meant a
talking about
restaurant in the
traffic
vicinity.
in the parking lot that everybody is counting for every application
Right.
is a disaster.
We know.
Billy Sol Estes.
Okay, so, moving on then?
Yeah.
Okay.
Move on.
Next on the agenda, application to be heard, case number 234, 1014 Academy Street Corporation. It's a continuation of the April 7th meeting. Block 2013, Lot 3, 14 Academy Street. Preliminary and final site plan. Applicant proposes to divide the premises into separate uses for a restaurant, continued use, and retail stores. Welcome back, council. Please proceed.
Could be my ears.
Is the microphone working? As far as they can tell, it's working.
Okay, I'll speak loud.
Okay.
Much more so frequently. As you recall, I can't believe it was April that we were here last, but it's been some time. There've been some issues that the chairman's aware of and I'm aware of that caused us to be delayed for the period to get back to you. But we're here this evening. Mr. Lanzafama, our planner, had testified at the last meeting. He'll not be here this evening because he completed his testimony at that time. Our architect, David Jablanka, will be here to fill in all the gaps that were left. Mr. Miller particularly had an issue with the ramp. He wanted to see the ramp before we could go ahead and vote on the application, if you recall. The new plan, which we'll mark shortly, will show the ramp both on the architectural and on the engineering plan. The ramp will service the tenant space in the center of the facility. The restaurant itself had no access problem, had no access issue, nor does the tenancy to the extreme left side. It was just the tenancy in the center that required handicap
Maybe if
accessibility.
you pick the mic up, Stephen, that'll work better.
Is this better? I'm sorry. I can repeat some of that if you didn't hear it. The bottom line is that the ramp will service the center tenancy space. It's now shown both on the architectural and on the engineering plan. All the variances that we had discussed last time are all existing conditions. There are no new variances required other than those that were previously approved by this board. As pointed out by the chairman and by Mr. Lanzafama in his testimony, the fact that we're converting an entire restaurant to restaurant and retail actually reduces the parking demand of what would otherwise be required. Mr. Jablanka has some renderings which he'll distribute during his testimony, which show an improvement to the facility, to the facade, which we hope will meet with your approval as well. So I'd like to call our architect, David Jablanka, please.
Architect was previously sworn in, correct? Was not? Okay.
No.
Then,
Please raise your right hand. Do you swear or affirm the testimony you give this board is the whole truth?
I do.
Please state your name and address for the record.
David Jablanka. The address is 257 South Ridgewood Road, South Orange, New Jersey.
Mr. Jablanka, are you a licensed practicing architect in the state of New Jersey?
I am.
For how long have you been so licensed?
I got my license in New Jersey in 1995.
Please give the board the benefit of your educational and professional background.
I went to Syracuse University where I got my architecture degree. I then studied urban planning and historic preservation at Columbia University. I currently have licenses in New York, New Jersey, Pennsylvania, and Connecticut. I'm NCARB certified and a member of the AIA.
And you've testified before the zoning board in South Orange previously,
The zoning board, not the planning board.
and you've testified in other communities as well.
Yes, at least a dozen in New Jersey.
Are Mr. Jablanka's credentials accepted by the board?
Anybody have any problem with that? Yes, we accept.
Thank you very much. David, do you prepare a rendering to distribute to the board before you begin your testimony?
I did.
May I submit that, Mace? I guess this will be A2.
A2, right. Could you tell us what it is, please?
You need to speak in the microphone.
Speak into the mic.
It's a color study of the exterior of the premises.
Is dated and who drafted it?
But it-
I prepared it, and the date is today. I think it's 7/7/14 in the corner.
We can pass it.
It's the Academy Road elevation showing some color studies. We also have some actual, paint chips here with the colors that were selected. I don't know if anyone wants these.
Are the colors that you selected neutral colors as compared to what currently exists?
Yes, the colors are actually based on colors that we find on Town Hall and some of the other Tudor buildings in the neighborhood. It wasn't our intent to change the facade, so the kind of half-timbered nature of the building lends itself to these colors, as well as some of the historic buildings in town.
Would you please walk the board through the architectural plan which you prepared?
Okay. Okay. On the exterior of the building, we're not doing very much. The existing facades are pretty much staying the way they are. We're changing the colors, obviously, based on the new color scheme. We're modifying the signage, which I believe was already presented, and would be in conformance with the signage ordinance based on the linear footage and the frontage of the various tenants. We are adding some gooseneck lighting, so we're going to have front-lit signs. So we're adding a little bit of lighting to the front elevation and the side that faces Irvington Avenue to illuminate the signs.
With respect to the interior space, would you describe that to the board as well?
Sure. Currently, it's all being used as the family buffet. It's a buffet restaurant.
Can I ask which drawing you're referring to right now? Is that SK1?
SK1, dated May 14th, 2014.
As this was submitted as a
Yeah.
part of the proposal, it does not require a marking this evening. Go ahead, David.
The proposal is to subdivide the existing single-tenant use into 3 tenants. Apparently, this is actually returning the building to a condition that existed when the current owners purchased the property. It was 3 tenants, and we're proposing bringing it back to those 3 tenancies. The locations of the divisions between the tenancies are where they previously occurred. There's an existing block wall that creates a good fire enclosure between the proposed restaurant and tenant space number 2. And then between tenant space number 1 and 2, there's actually an elevation shift between the floors there. Tenant 1 is actually 3 steps down from tenant 2, which is why we chose to divide the space in that location.
So that would be an appropriate location to divide these tenancies. Is that correct?
Correct. My understanding is that at the last meeting, there was some concern about accessibility. Currently, tenant 1 is accessible only through the rear hall and down a ramp. It continues to be accessible that way. The rest of the space is accessible through the entrance that's at the southwest corner of the building. That's at grade. When the tenancy is divided between future tenant 2 and the restaurant, we're proposing now to add a handicapped ramp to get into that middle tenancy. So all 3 spaces will be accessible.
And that ramp is demonstrated both on your plan and on Mr. Lanzafama's plan as well, is that correct?
Correct. I showed on my plan, it's detailed on Mr. Lanzafama's plan.
I have nothing further of Mr. Jablonka unless the board has questions of him.
Good evening, Mr. Jablonka. The renderings that I'm looking at, both the SK1 as well as the color study,
Yes.
show a step up for both tenant one and the existing restaurant. Is that the condition that you're proposing?
There's 2 steps up at a stair at tenant 2.
So tenant one and the
At
restaurant?
tenant 1, there is a step up. There's a step up from the Academy Street entrance and the corner entrance. There is a ramp that takes you in from the hallway in the rear. There's an existing ramp that takes us in through the rear entrance.
And that would be therefore accessible for handicap, is that correct?
It would be, yes.
Can I ask just a follow-up question?
Sure.
Let's assume that, as it's done here in SK1, that space number, well, whatever it is, tenant 3 is the restaurant. The only way that a handicap, I mean, I just want to talk this through and make sure I understand it. A person who is handicapped would not be able to enter through, if they had problems walking, they would not be able to get in through the front door, but they would have to go in through space for tenant 2?
No.
No.
Are you talking about the restaurant?
Yes.
The restaurant is at grade. You can go straight in the front door.
Okay. So it's only space number 1 that,
Space number 1 is the only one that you would have to go through the back door to get to.
and, okay, so let's play that a little further. That would mean that those 2 tenants would have to be open at the same time, right? I mean, let's say let's say tenant 1 stays open later or opens up earlier,
No, tenant, they both, it's a common corridor in the back.
right?
So if tenant 1 wants people to come in, they can come in. Tenant 2 has access off the street with a ramp, and the restaurant has access off the street with the ramp.
Where are the people, I'm sorry, where are people entering? If they're coming into space tenant 1, where are they entering from?
If I was a normal tenant, I have an option. There are
Right.
2 doors. There's currently one on Irvington and one on Academy
Okay,
Street.
now let's say I'm not ambulatory, where am I coming in
I
then?
would come in on Irvington
Okay.
in the back hall and come in. That's a
Okay.
public hallway that exists now, and it's the only accessible route into that area of the building currently.
Okay.
So if this plan were approved, there'd be access from into each of the spaces, is that
Just a
correct?
follow-up to that question.
Correct.
So for tenant 1, being that it'll probably be retail or some use like that, chances are where the bathrooms are and so forth, they'll probably build an interior wall across for storage and so forth, which is typical for a tenant construction. How will that now work with your handicap access through the rear, through, I guess, their back area or whatever? Are you going to have plans in place where that is not going to be walled off, or it'll be walled off separately so that access way is already always open?
Okay, well, there are 2 issues. One is, at a point that someone decides to do construction in any of these tenancies, they will have to go to the building department and comply with all the appropriate codes, including the barrier-free subcode. So there's no way for us to predict what might happen, but the building code governs how they can subdivide this.
Other questions from the board?
Just really quick, about the tenant 1 bathroom, is this a proposed, or is that going to be a finished, or is that just a
These are all
conceptual
existing
space?
bathrooms.
What's that?
These are all existing bathrooms. There's no proposal. The proposal before the board is to subdivide this into 3 spaces, and the only construction that's being undertaken on the interior is an interior wall subdividing tenant 1 and tenant 2, most of which is already in place, and a wall that's running across the back of tenant 2 that is allowing access, a second means of egress. There's no plans to redo any bathrooms or interior spaces here at this point.
just as a follow-up, and I'd like to ask our own counsel, if, is this plan approved as proposed? Is it supposed to be up to code for, to today's code, even though it was existing bathroom? Is that a pre-existing non-conforming use? Does that remain? Or is it supposed to all now be brought up to whatever codes are to today's standards?
First of all, our issues are more zoning than code issues. The code issues get handled by the building department if there's an approval. Then they go through the code compliance aspect of whatever you're building, once you get an approval from the board. So it's not something the board handles,
Okay,
code, but it's a good question, but.
all right, thank you.
Other questions from the board? I do have one other question. I'm sorry, I'm sure this is painfully obvious, but I'm just not remembering. On SK1, under future tenant 1, there's the square footage, and then it says M use 17 people, B use 5 people, and then for tenant 2, M use 60 people, B use 18 people. Can you just remind me what that means?
Well, M uses are mercantile, B uses are business uses, and I was just laying out what potential tenancies might have as building code-related occupancies.
And in
Because
this
in the
case,
building code, it's got different occupancies per square foot based on uses.
and which one did you use for the calculation, for any of your calculations?
Well, the calculations for signage have nothing to do with
Right.
that. It has to do with linear footage of frontage. And the parking calculations have to do with the square footage, so it really doesn't,
So it's just,
the
it's just
the
illustrative. It
occupancies
doesn't-
don't matter.
It doesn't have any particular meaning, it was just.
It doesn't have meaning to this board. It would have meaning to any tenants coming in might have to provide different numbers of bathrooms, egress travel routes, et cetera.
And can you just describe the distinction between mercantile and business in this case?
I'm not sure that business, I didn't do the zoning analysis of this, that was the planner's part of the job, but mercantile is retail. Business could be any kind of office space or something like that.
An insurance
And,
agency.
and,
would
and,
be
and I believe even in our central business district, there are some businesses that are allowed in the retail spaces, so it's an
So
occupancy
this
issue.
comes directly from the zoning here? That's where you take
That comes
the-
from the building code, it's the Uniform Code of New Jersey.
Okay. Susan, I believe I saw you had a question?
Yes, my notes indicate, and I just want to confirm, and I'm not sure it's really your testimony, but my notes indicate from the last meeting that you were going to eliminate the existing pole sign at the corner.
That's correct. We
Okay,
agreed to
so
that.
you will, even though it
Yes.
hasn't been eliminated on the revised plans?
That's correct. I apologize.
Okay, so that's one that is, and my understanding also from my notes is you were going to provide some bike racks
Yes, you are correct.
so that you will
We'll have to
plan
revise
on
the drawing to show
having
that, yes.
some bike racks as well. Okay, I just wanted to confirm that from the last meeting.
I apologize, Susan. Mr. Lanzafame has had some issues that
No,
unfortunately.
that's okay, I just
But
wanted to
we- yes.
confirm that that's
Yes.
on the record, that you
Absolutely.
continue
We
to.
will do that, as we
Thank you.
agreed.
And just from the last meeting, I believe questions were raised about your parking area, that it would have to be, or it was suggested that it would be redone. Is that going to be redone?
I mean, the resurface?
Resurfaced?
I believe so, yes. We had testified to that last time.
Okay.
That's correct.
Patrick, you had
I
a
just
question?
want to Susan's point about the bike racks, I believe there's an ordinance
Yes,
in effect regarding the number of bike racks. So
yes.
that would have to be complied with. Okay?
Do you recall the number off the top of your head, Pat?
It varies on the.
Okay, depending upon the size of the structure and the uses. Okay, we will certainly comply with whatever is required by the code.
And I believe one question was asked, not by me last time, but by another member,
Michael?
was asked by another member about, have you explored, or will you explore, I should say it was at the time, will you explore obtaining additional parking?
Mr. Kwok is here to testify to that.
Excuse me?
Mr. Kwok is here to
The
testify to
owner.
that.
The owner.
All right.
Do we have any other questions for this witness?
Yes, I have another question, I'm sorry.
Please.
How come your microphone works better than everybody else's?
You can have it if you want.
He has a deeper voice.
The elevation, the proposed ground floor plan on SK1, I'm looking at that and also looking at number 2, the proposed Academy Street elevation. And when I look at the elevation, I see it by the ramp, it looks to me like, it looks kind of like a door that's next to the double door, to the right of the double door, under where it says 10 and 2. Is that in fact a door? Is that a window? Is that what is that just to the right of the
There
double
is
door?
a door on the facade, but it doesn't exist inside the building. So it must have been walled over at some point. We are not intending to reopen the door, so.
Is there a
it'll be-
closet behind it, or is it?
There is a closet, there's a storage room back there, and there's a sheetrock wall, I guess, over it. So we're not planning to open it up again. It'll just be painted out like it is now, and you won't notice it.
The other question I had also regarding right around 10 and 2, when I look at the colored elevation, it looks kind of like there are canopies, 3 maroon canopies under 10 and 2. Are they in fact canopies, or are they just merely painted on flat?
There are currently canopies there, so the intent would be to replace the canopies with something that would be in keeping with the ordinance for canopies.
Okay, that wasn't
What's
reflected.
current, it's an existing condition.
No, that's fine, it just wasn't reflected on your ground floor plan. So I just wanted to see, which is the case.
Okay,
All right, that's all, thank you.
sure.
Okay.
Just, any consideration for pursuing lead for commercial interiors, any type of sustainable components for the outfit, or just the shell?
I don't know. I don't know if the owner or any of the tenants would have an interest in doing that, but at this point, we're not building out any of the spaces, so honestly, we're painting the exterior and putting up 2 sheetrock walls
And a ramp.
and a ramp.
Okay, any other questions? Any other questions for this witness? Okay, so any questions from the public for this witness? Okay, hearing none. Thank you very much for your testimony.
Thank you, Mr.
and-
Chairman. Thank you, David.
Counsel?
Andy?
Has he testified before? Good for you.
I don't see it listed in the notes.
Good evening, everyone.
Please raise your right hand. You swear or affirm the testimony that you will give this board is the whole truth.
Yes, I do.
Please state your name and address.
My name is Man Kwok, or I call as Andy. My address is 14 Academy Street in South Orange, New Jersey, 07079.
Andy, are you and your family the owners of the premises, which is the subject of this evening's application?
Yes,
You're aware of the fact that you were requested by Mr. Miller and others at the last meeting to try to investigate whether there's any potential for off-site parking. Have you done that?
yes, I do.
Please tell the board what efforts you've made in that direction.
Yes, I have walked over to a Just Be House to ask them if I can rent some parking space, but they told me no because they told me they don't even have enough space for themselves, so they turned me down. So I went across to a PNC parking lot. I spoke to one of the manager there. He said he would talk to his boss and get back to me. But as far as I know, his boss never get back to me. I leave him with a cell phone and everything. He never get back to me.
So you never heard back from them at all?
No, never.
And those are the efforts you made to find off-site parking within the neighborhood?
Yes.
Thank you. I have nothing further.
Okay. Questions from the board? Any questions? No? Professionals? Susan? Patrick?
Just how many, I'm sorry, how many times did you try to contact this person?
If I'm not mistaken, because the manager from the parking lot from PNC Bank, he's like normal our customer from the restaurant, so he been here a lot. So we had asked him every time he asked him. My mom's always asking, "Do you talk to the boss? Do you talk to the boss?" He always say yes, but eventually, the boss never called me back. I leave him with all my cell phone, my home numbers, and my cell phone number. If you're asking how many times, I would say more than 10 times, because he's like our usual customer for the restaurant lunch hour.
But no official, I'm sorry, just make sure I understand this. You asked kind of in a casual way when he entered into your restaurant, but you never officially approached him or had a meeting?
Yes, I did. The first time when I went inside there, because I don't know who's the manager, because the manager always changed. So the first time I went inside to the buildings and asked where the manager office or supervisor office is. I went inside there to speak to the person directly. And the first time he told me that he would talk to his boss and get back to me. So I leave him all my information, my cell phone numbers, and the restaurant number. But as time goes by, I never hear anything from him. So like when time goes by also, the manager come to the restaurant, also buy food all the time. My mom's always asking, "Did you talk to the boss? Did you talk to the boss?" He said yes, but it could be no from him, but he always say yes to my mom that he talked to the boss, but I hear nothing from him.
Have you ever tried to approach the owner of the building or contact the owner of the building?
That information they do not allow, they don't give it to me because this is private number. The manager will not allow to give it to me. He just told me that he would talk to his boss to get back to me.
Okay, thank you.
Thank you.
Any other questions from members of the board, professionals?
Thank you.
Just one
Just
other
for-
sorry. I just
No,
want to make
please.
sure I understand the park, because I know parking is a big deal. Did you pursue any other avenues for additional parking besides the route that you just mentioned? Was there any other inquiries, any other parking spaces, or?
No, I didn't. I did not because Jaspy's house and the PNC is the one that closest to the restaurant. So that's why I asked around my neighbor. But anything farther than that, no, I did not go that far. Okay. Because it made no sense for the customer to go all the way and come back. So no, I did not go.
I'm sorry, maybe I didn't understand you, Mr. Kwok. Did you say you did reach out to Jespy?
Yes.
Yes, I did
Okay.
ask Jaspy. Also, the manager there, he's told me that they don't have enough space for themselves, their own truck. So he told me on the spot, no, right away.
Thank you.
Okay. Again, any other questions from members of the board, from our professionals? Just, by the way, for future reference, you can always find out who the owner of a property is just by approaching the township, even if the people who actually are tenants of the building don't tell you. The owner pays real estate taxes, and therefore that information is filed with the township. The tax assessor and tax collector would have that information and would make it available to you. So just for future reference if it comes up again. Since I hear no questions from the board and our professionals, and open up to the public, anybody from the public have any questions for this witness? Okay. Hearing none, thank you, Mr. Kwok. Any other
I have no
testimony?
I have no further witnesses. Very, very briefly, I'm not going to make a long closing remark, because this whole case just took about 7 minutes. Parking obviously is an issue. It's been an issue in South Orange for many, many years, but this business has operated for at least the past 10 years with the parking condition as it currently exists. We have an improvement in our opinion, and as it's been expressed previously by members of the board, because we're going to convert at least part of the restaurant to retail, which has a much less demand for parking. The parking is what it is in South Orange. It works. It has worked for years. It's not ideal, obviously, but because of the conditions that currently exist and the number of, Mr. Lanzafama testified to, other public parking areas around within the proximity of the restaurant, including some metered lots, they currently exist, they continue to exist, and the process has worked because the business has been ongoing for at least the past 10 years. We're seeking to make an aesthetic improvement as demonstrated by Mr. Jablonska's rendering to you. It will be an improvement of what currently exists, and we're just seeking a change of use to reduce, to some extent, the parking demand by dividing the restaurant into several uses, including retail and/or business. So it would beg the board's indulgence and to provide a positive response to our application.
Thank you, counsel. So I guess, any other comments from the public before we go into our deliberations? Okay, hearing none. I now open it to discussion to the board. Don't everybody jump in at once. Michael, please.
Look, we know parking is an issue, and it has been on every one of these permits, whether it's Papillon or Rickleton's. I think it just would be unfair to penalize this owner by holding it, even on, I'm such an advocate for parking, but to make this owner an example, I just think would be just not right to do based on what we've approved recently. So very frankly, for that reason, and subject to all of the agreements that the owner has indicated that he will do, of which is on record, I reluctantly move for approval.
I second it.
Okay, any further discussion before we take a vote? I do want to offer a friendly amendment, unless there's any further discussion before we go to a vote. But is there any other discussion on the subject? Okay, I just would like, I think that there were some things that were mentioned which, in discussion, in particular by our planner towards the end, which I want to make sure we get on the record and are incorporated into the resolution. So if I might just add a few things that I think I heard.
That is my intent, to incorporate everything that literally went on the record.
Okay, so in particular, I think what we need to see are things incorporated into the drawing and incorporated as part of the resolution. One was to add the bike racks, to have a number that is consistent with the ordinance, to remove the pole signage at the corner, that the owner has agreed that he'd be resurfacing, I think it was the parking lot, you said?
Yes.
And that the drawing will reflect that the on either side of the entrance to space for tenant 2, that there would be canopies on either side of that entrance. That it is canopies, which is not reflected on drawing SK1. And those are the things I heard. If I left anything out.
Yeah, I will add a couple of other things.
Oh,
The removal
please.
of the pylon sign, even though that was on record. I will also add a decorative rail on the ramp of some sort. I mean, there's not really a detail of it, so there is a ramp on the rail, and that's required by code anyway, but some kind of decorative rail. Let me just say, I think we've got the pylon sign, we've got the colors that were indicated. I can't think of anything else for the moment.
Okay.
And with that, I'll accept your friendly amendment and amend my motion to add those other
Everyone
issues.
else, is that okay with you? Okay. Yes.
Mr. Chairman, I'm looking at notes for this application. I actually wasn't here on the first meeting date, but I have
Alice,
notes.
Shame on you.
Wonderful job in your absence.
Notes from the attorney who was here, and I see that she said that there was it that the recycling and refuse was going to be contained in the garage-type space in the building? Was that a condition?
Yeah,
That's what was testified to.
yeah, I believe that.
That was just testimony, but that's part of the application, okay. And he was going to repaint? Was that the exterior?
That's what you have in front of you now.
Right.
Okay. That's it.
Okay. Okay. And those are all, you would agree, counsel, consistent with what we've discussed? Okay. Therefore, we have a motion, we have a second, and Jetta, can you please take the roll?
Yes, Mr. Colton-Max?
Yes.
Mr. Miller?
Yes.
Reverend Wilson?
Yes.
Mr. Allen?
Yes.
Mr. Chambers?
Yes.
Mr. Lerman?
Yes.
And Ms. Harris?
Yes.
Okay.
Thank you all very much. I really appreciate your.
Good luck.
Congratulations, good luck
Good
to
luck.
you, sir. All right. So now we're going to move on. The next item, case number 231, Luther P. Turner and Hazel A. Turner pending, Block 704, Lot 1, 14 Kingman Road, minor subdivision. Applicant is proposing to subdivide the existing lot to create two lots with the intent to construct a one-family dwelling on the new lot. It's my understanding that we do have an update, although nothing for this board to act on this evening, so.
Yes, Mr.
Counsel?
Chairman, there was an appeal filed from the determination by the HPC that the lots should not be subdivided. The Historic Preservation Commission decided that it shouldn't be subdivided. There was an appeal taken from that decision to the zoning board. Transcripts of the HPC proceedings have been presented to the zoning board this past week. And so it's scheduled tentatively for the August 5th meeting of the zoning board, to be heard.
And just to go over what the possibilities are, the zoning board could decide to accept the recommendation of the Housing Preservation Commission, or they could reject it. If they rule in the applicant's favor, then they come back here. If they rule against the applicant, then what happens?
The applicant can appeal that to the courts.
Okay.
But under the ordinance, Susan, I believe, if the applicant agrees to comply with the board's decision, the HPC's decision that it should not be subdivided, is that still the notice provision and the time within which to see whether or not there's an able buyer, as it is with demolition?
The demolition, yeah.
It's similar?
I believe so. I can't remember exactly what that process is, since we haven't really
We haven't done
gone
it
through
yet.
that before.
We haven't gone through it yet. I think that's the other option.
Okay.
Mr. Dwyer, isn't there an intermediate step? If the zoning board turns it down, don't they have the right to appeal to the town board first before court,
I believe
or
it's direct-
simultaneously,
I believe it's directly to court, Michael.
directly to court? Okay.
Okay, so, all right, now we're on to the discussions.
Are we done with that?
Yes.
I just had a couple of questions, if maybe somebody could
Go ahead.
give me some detail. How big is this lot?
It's pretty big.
And
Pretty
how,
sizable.
and if they do,
Is that's the technical term, pretty
yeah,
big.
pretty big.
Pretty big.
So if they split it, what would be the side yard or easement of
They
the
would-
existing building, the existing house, and what would be the
They would
acreage?
they would need variance relief. As I understand it, they couldn't divide it and have two conforming lots.
Okay, so they would have a offset less than 10 feet or whatever it is.
Whatever the
Whatever it
dimension
is.
This case, now that you've asked that question, this case started prior to a number of our newer members joining the board. Is that correct? Yeah. Okay, so if it reaches, I mean, we certainly have the materials now, and Jetta could provide them to you now if you wish. Is that correct? Okay, so the question is, do you want to wait until you know that you're going to actually hear it, or do you want to try to get the answers to your questions now? If so, you can let Jetta know, and she can provide you with all the materials.
It would be great to have it prior, but
Okay.
the basic questions I wanted to know was what you just told me, that if they do subdivide it, will they be able to conform? And because I don't know how, because I know a lot of these spaces are pretty big.
Okay, so Jetta, we have
It is pretty big.
3 new members, so can you please see that we
It's not
get
big
they get the materials for this meeting, whether you want them or not? Kidding. Okay, any other, I'm sorry, I didn't bring my materials because
No, it's
I
perfect,
knew we
yeah.
wouldn't be discussing
It's
it.
just that it's come up a couple of times, and it's been passed over. I just wanted to get
Fair
some
enough.
information.
Fair enough. So I have to ask a question I should have asked before the meeting. I know that in general, I'm supposed to literally read everything that's on this page. I'm going to now ask you, since there are 1, 2, 3, 4, however many resolutions there are, I can't count that high, am I supposed to read for the record each one of these resolution descriptions?
I would identify them by the number, Mr. Chairman.
Okay, so I'm going to identify them by the number. So we are now going to have a discussion of resolutions 2014-186, 2014-187, 2014-188, 2014-189, 2014-190, 2014-191, 2014-192, 2014-193, 2014-195, and 2014-197. Just for my own, to make sure I'm not missing anything, 2014-194 and 2014-196 are not listed here. Those were other resolutions that the plan, I'm assuming? Is
That's
that
correct.
correct? Okay. All right, so, so having said that, I would ask our planner if she could describe what the resolutions are that are before us. These are coming to us from the Board of Trustees for our consideration, not to approve, I understand approve the plans themselves, but to approve, perhaps you're going forward with producing a plan for our consideration, for the public's consideration. Could you comment on this, please?
Yes, and my understanding is there were no maps attached to the resolutions. I have a composite map, okay, just for purposes of you knowing when you have a study, you will have maps that specifically relate to each one. So just for purposes of, one is an aerial and one is a tax map. This, for those of you who have been involved in a redevelopment study before, which I know several of you have, at least. Under the redevelopment law, there are two steps to a redevelopment area plan. The first is a designation or a study that occurs to determine whether the area to be studied meets certain statutory criteria that are listed in the state redevelopment law statute. All it does is as you will see, there is a boundary and a block and lot of the study areas. And then each of those lots within those study areas will be evaluated in the redevelopment study to determine, again, whether it meets the statutory criteria to be designated. It then, once the study is prepared, it's a factual study, it comes to this board. This board then holds a public hearing through a very, very rigid notice procedure to the affected property owners and to the general public. And then you will hold the hearing and permit any member of the public to comment on their thoughts about whether an area should, or the area should be designated. You then will then ultimately listen to the public comment and, based upon the study and based upon your own knowledge, determine whether you recommend, this is a recommendation, whether you recommend all, part, or none as redevelopment, as a redevelopment area or redevelopment areas. That then goes to, your recommendation then goes to the Board of Trustees, where they, by resolution, make a determination as to whether they accept your recommendation or they can, frankly, ignore it. It's ultimately their decision, and they determine and vote by resolution as to designation. The second step in the process is if it's designated a redevelopment area or all these areas, then a plan is made for those specific areas. And as those of you that have been through this process before, the redevelopment plan is a hybrid between a master plan for the designated area and an ordinance. It is ultimately adopted by ordinance by the Board of Trustees, but with input with the planning board. There is one other resolution that is part of this, and that is analyzing whether the entire village can be designated as a rehabilitation area. And that has certain advantages to short-term tax abatement, and it provides potentially incentives for improving areas and neighborhoods within the community?
Can you clarify, can you give us just a little bit more detail as to what it means for something to be declared an area in need of redevelopment or an area in need of rehabilitation?
Yes. First of all, there have been recent court cases that have clarified what some of the criteria are. And if you've heard the Glentham case, the Paulsboro case, that was focused on the E criteria, which basically was focused on quote, underutilized property, and there was some question as to, and other conditions, whether it related to anything. It was the junk drawer of planners, any other condition, underutilization. The courts determined that it had to be related to title, conditions of title. So that's been clarified. Under any criteria, there needs to be what's called substantial evidence. There needs to be a factual basis for determining whether an area is or isn't an area in need of redevelopment. Such things as faulty arrangement and design under the D criteria, faulty arrangement and design, certain utilization or overcrowding of property, obsolete layout, deleterious land use. These are just some of the consideration. If property is commercially used and is vacant and has certain unhealthy conditions or code violations, those would be a consideration. I would note as well as that there is a provision in the redevelopment law that permits property to be concluded, it's called Section 3, which in and of themselves do not meet the criteria, but are necessary for the effective redevelopment of the area. Now, that can't be the majority of property, but certainly if there's a piece of property that is necessary for the effective redevelopment of the area, that has to be analyzed. But that is another component part of the criteria. One of the first things that is necessary to be done is gather information about each of these properties through tax records, through code enforcement, through fire, police, to determine what the historical basis and conditions have been on those properties. So that kind of, I hope that answers a little bit. But there's A through H. H is essentially not used. It's that it's compliant with smart growth principles, but nobody's been able, frankly, to determine exactly what that means.
Does the, in a plan or something being designated an area in need of redevelopment, does that enhance the ability or change the ability to use the power of eminent domain, for example, or?
Well, I'm glad you asked that question. Actually, I neglected to just comment on one aspect. The redevelopment law was amended last year in the fall. It went into effect December of 2013. And it was in response to a number of the court cases as it relates to process and the sensitivity to the eminent domain issue. It provided an option under redevelopment. It said that for a municipality to move forward with the redevelopment study or an investigation, they had to determine up front, the governing body, when it forwards the resolution to the planning board, have to determine whether they are going under the condemnation or non-condemnation option. And they can choose which one up front, or they have to choose which one up front. Now, if they choose one, for example, if they choose non-condemnation, that doesn't mean they can't go back and reconsider it under the other option. It did not change really didn't change the substance of the criteria, whether you were under condemnation or non-condemnation. There were some other minor changes, but not related to this, but under rehab, environmental conditions were included, and there were several other changes, but that was a big change.
Do these resolutions, the ones that deal with redevelopment, do they fall on one side or the other of the divide you just described?
Yes, they are specifically under the condemnation.
Okay.
And there was quite a bit of discussion, open discussion regarding that,
Okay.
with input from a number of the committees.
Right. Unfortunately, by the way, we're not joined by any member of the governing body tonight for a number of reasons. Just unfortunately, that's the way it worked out. So that's why we're not going to hear from anybody as to, exactly why this was done the way it was done.
I just have a quick question.
Oh,
then.
please. Go ahead.
Can you help me understand which number
No.
associates with these?
I'm sorry, we didn't get, and it's a good question, it's a
Okay.
reasonable question. There were, what we tried to do was attempt to just give you a sense as to what different areas were being considered. We will give you that, a specific
The reason I asked is
map.
that number 9 looks like the property we just voted on.
Yes, and it is,
Okay,
it is.
okay.
You are correct.
Ms. Gruhl? Yeah,
I had the same question. I didn't see the block lining up, though.
obviously, I've dealt with these kind of situations throughout the United States where they've been taken for economic reasons, where, for argument's sake, you'll condemn a retailer to put in a Walmart because the revenue generated by Walmart is far greater than. And obviously, a lot of these have come under legal scrutiny, including the latest, one of the largest ones was New London, Connecticut. But usually when you're reviewing an area for redevelopment, you're looking at large blocks of contiguous land. And here we've got it helter-skelter around. I mean, for argument's sake, number 5, I mean, I don't know how big the parcel is from here, but even if you said you're going to redevelop it, I don't know what you're going to redevelop it into, just looking at the size. And other than number 9, or number 6, whichever way you want to look at it, I guess it's number 6, is a larger parcel. But was there a rationale as to, again, why skipping some of the houses, yet taking other of the houses?
Yes, there was. There was an extensive amount of discussion regarding what properties may be appropriate for redevelopment. Remember, redevelopment, as you know, is just one of the tools in the toolbox in terms of revitalization of an area. There has been for a number of years in the master plans talk about revitalization of the Irvington Avenue corridor. So that has been a focus of the village for a while. You're certainly not going to clear, as the old urban renewal projects used to do, clear an area and start over. The intent was, and I only can speak from being involved and listening to the committee and understanding and having some input into this. The intent was to be selective and to look at opportunities that may exist, and that was what this was.
See, what I don't understand is if you're going to examine an area for redevelopment, you're going to examine the whole area. yet the town board or the trustees have literally specifically just highlighted certain areas rather than a corridor.
Well,
I'm
but
a
don't
little bit
forget the
confused by that.
rehabilitation designation that goes throughout the village, so that those areas that are not specifically under redevelopment would be considered under rehabilitation. And certainly, if in fact any or all or whatever, some of these are considered, that the plan would certainly be and we've seen this, a plan that may include rehabilitation and redevelopment together as a comprehensive plan for the corridor. So that is a way of being comprehensive.
It was
for
interesting,
that.
just final, to note that watching the trustees meeting, when they passed these resolutions and read every one of them individually into the record, that they said the planning board, the statement was made that the planning board was familiar with this. And I've got to tell you, I mean, if we were, my senior memory's not working.
Please.
I just want to see if I understand this. Rehabilitation or redevelopment both carry with it the option of condemning property?
No.
No.
Rehabilitation designation absolutely statutorily does not.
Okay, but redevelopment does.
Redevelopment, if it is a condemnation option of redevelopment, it does.
Right, okay.
Potentially.
Potential.
If they allow it.
Potentially, it's not.
And that's fine. And do both redevelopment and rehabilitation carry with them the opportunity for tax abatement?
The redevelopment for 30-year, what's called long-term tax abatement, the rehabilitation, no, short-term tax abatement.
And what is short-term?
Short-term is, oh my gosh, I just
Is it 5
I
years?
just drew a blank.
5 years.
5 years.
Thank you.
Ms. Gruhl, the properties in question here, numbered, say, 1 through 9, were the property owners, are they aware that their properties are under this type of examination and up for redevelopment and potentially for condemnation?
My understanding that at least some of them are, if not all, but I can't attest to that. I was not directly involved in that.
At what point in the process, just to follow up the question if you don't mind, at what point in the process must the property owners be informed that their properties are in it?
Well,
When the notice occurs,
Right, when
when
you
the
have to
study's
notice.
done.
and
When the study is done? When
Yes.
the draft of the study is done for it to come before this board, before the public
No,
hearing?
it's, a study is not a draft, it's a study, okay? It's
Okay.
one of the factors that is being considered in your deliberation as to whether you recommend or not. But the
the notice requirement
notice, yeah,
is much stricter than it was, and partially because of the case you were involved
in Harrison.
in Harrison.
The DeRose notice. It has to say specifically that
Condemnation
condemnation,
is an
that's the
option.
condemnation option. They are given notice several times before and asked that they can attend and be heard.
Can you be more specific?
And they can
Well,
come
you
and
said several
study.
times. I was just trying to say, like, what is
Oh,
it? You know, they get notice
two-
30 days before, 15 days before, and
Okay,
5 days. That's what I'm trying to
it's one time at least, if I remember, it's 2 weeks before the hearing that they have to be noticed, at least that week, and then one time before that week. So it's 2 times within 10 days before the hearing occurs. They get individual notice, then there is the public notice that occurs.
And what is the public notice, aside from this meeting and the Board of Trustees meeting where it was discussed? What is the public notice?
Publication.
Publication. And when will that occur? When must that occur?
I don't know the date on the top of my head, but
Okay.
I'm sure that because condemnation is an option, the township's going to be very sensitive to proper notice.
Okay.
And the study has to, in the notice, it has to specifically state that the study is on file and can be looked at, during business hours. So, and they have the right to to go and look at it, and that's specifically noted in the notice.
Providing, I mean, assuming the planning board tonight passes these resolutions, when would the study commence, and what do you estimate the time to complete?
Would be within the next 3 months,
So
would be finished.
with these being, it looks like most of these are redevelopment with 2 rehabilitation, right? I just ran through it myself. I just want to make sure. Actually, 1 is rehabilitation.
Just the last
Yeah,
one.
The
that's
last
for the
one.
entire
It's
township.
just broken into 2 pieces.
Yeah, but that's for the entire township. It's not for any one of these 9. It's for everything. Your house, my house, everybody's house.
Okay.
Literally everybody.
So is there, and maybe I'm jumping ahead, but in terms of redevelopment, is the redevelopment that potentially could happen based on the study, is it housing? Does it have to be housing related since it's part of the housing law, or is it?
No.
So,
No. It can be industrial, commercial, it can be anything. It can be public land.
and will the study that you guys are going to do, it will suggest or
No,
recommend?
not the study. That's what this is, and this is the catch-22, kind of. The plan as to what, if it's designated and what happens, that's the next step. You don't get to that at this point. All this is these are these areas that are needed to be studied and determine whether they meet the statutory criteria to be designated.
Okay.
And then if they're designated, then the next step is, okay, now they're designated or not, or modification, then what is the plan for the area or areas?
So the study is to determine if they should be or should not be
Whether they
designated
meet the
as-
criteria.
Suddenly having that depends on what the definition of is.
Thank you, President Clinton.
The catch-22 is, if I understand this, if this board votes to pass these resolutions, then that essentially authorizes the study, correct? Doesn't do anything other than authorize the
That's
study.
correct. That's correct. That's all
And
it
then the
does.
study comes, the study comes back, and then the board could authorize the study, but there won't be a plan.
No, the board would then listen, review, and then recommend. Okay? And they would recommend either all the areas meet the criteria, some of the areas and sites meet the criteria, or none. And that's what then would be forwarded. You would take a vote on some action based upon that
Right.
hearing, and then that would be forwarded back to the Board of Trustees.
But in all of that, if you recommend to the Board of, if this board recommended to the Board of Trustees, that still wouldn't mean there was a plan of what would happen to those
That's
pieces of
correct.
land.
That's
Just
Absolutely.
that they meet some written criteria that it's
Correct.
okay to have a plan.
Correct.
That it's okay to designate it.
Got it.
That's all.
Is the study only going to focus on these plots?
Absolutely. That's correct. And,
Okay.
and it's very specific. You cannot study or not study any area that is out or whatever of the boundaries. That requires an action from the Board of Trustees to say, oh, okay, now we want you to add lot whatever. You cannot go out of the strict.
You need a resolution to do such.
That from the Board of Trustees.
Can we make the recommendation to expand the scope of their study?
And I've seen that happen, and you're absolutely correct. If you say at the end of whatever, gee, you should have thought about lot, whatever, and we recommend that the Board of Trustees consider this as a redevelopment area or study as well, yes.
Okay, because I had the same question as Mr. Miller, like how were these 9 properties selected? And whether, they should probably consider doing a survey on their surrounding areas, surrounding properties to determine whether they should be included. So that would be my recommendation.
Yeah, I think unfortunately, I think it's a good idea. I think unfortunately, we would have benefited from having, if not the members who are on the Board of Trustees, we would have benefited from having perhaps some representative of the Irvington Avenue corridor, business development, blah, 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 group. And because I know that they put well, I don't know. I believe they put a certain amount of thought into this and could explain why that's the case. I was really hoping that somebody would be able to come. It didn't turn out to be the case. I mean, I suspect we can direct that question to them, and if we were, just to ask this question, if we were going to ask to expand this or suggest that we expand this, do we have to do that now, or can we do that at a later point?
At a later point.
So we don't have just one bite at the apple here, but I would specifically ask, and Jetta, perhaps it might be a good idea for us to initiate some dialogue with I think there are 2 trustees on the Irvington Avenue Central, well, I'm going to get it wrong, whatever I say.
There are actually
I don't think it
3.
should be the trustees. I think it ought to be somebody as a town,
Fine.
the town board who voted on this thing to.
Well, no, but I mean,
testify, to come up here and
I know,
testify.
for example, I think trustee Sheena Collum is on it.
Yeah, I
I think
know.
Stephen Schnall is on it, and I don't know who the third might be.
I think it's just getting a better understanding of the criteria that they use to select the properties.
Well,
One of the questions I had in advance and sent it in to Jetta was, will somebody, Sal or others, be testifying or explaining the redevelopment study, how determined, and the conclusions to determine it? And, you know, I would think if it's important to the town board to have this done, they would have had somebody here.
well, they will probably be here when it's done. This
Well,
is
I
a
don't care
very,
when it's
this,
done. You're asking us to vote on a blank check.
Well,
And I
it's-
don't understand the amounts.
I agree.
I just won't.
When you say
I
you
would
don't
agree with-
understand the amounts of what? What Susan's going to charge
No,
us?
no.
No,
I'm
with the
using that
implication- with the
figuratively.
implication.
They're asking for a blank check, and I don't know the amounts. It's the same thing here. I don't know why a study wasn't authorized to do the whole corridor, as Lillian
But
just.
if we have the right to expand, it would have been
That's
better. I mean,
later.
let me, in all fairness, I mean, I do want to be fair here. I can't speak for why all 3 of them aren't here, but I understand trustee Rosner is sick, and I understand that Adam, who probably could have spoken to this, and this is some good news to share, I think, he just had a child. His wife just had a child.
Wow.
And so there are reasons why 2 of the 3 people who would have spoken to this would have been here under other circumstances. So, you know, unfortunately, you know, I reached out to Jetta earlier today when it became clear that we might not have somebody here, and by that time, unfortunately, it was too late. So I just want to be fair about this, because I totally agree that it would have been a lot better to have somebody here who is knowledgeable about it, but at the same time, I just want to also be clear that I don't think it's because people didn't, you know, nobody thought of it or nobody cared about it. It's that circumstances conspired, at least to a certain extent, to
Okay,
make this.
I agree with what you're saying, but that doesn't mean we have to pass a resolution that I myself, I can't vote for it because I don't understand
There's-
all the machinations of it right now. And I do not intend to vote pro for
Okay.
it.
So
May I-
Patrick-
may I
Patrick,
just
what is-
comment
I'm sorry,
again?
can I-
Be tabled.
I want to ask council a question. What is the requirement in terms of, are we required to act this evening, or can we postpone acting on this until, let's say, the August meeting, so we can have some of these questions addressed?
Well, in my understanding of the local housing redevelopment law is it's the governing body's decision initially to make the predetermination of what areas they would like to have studied. And that's what's happened here. And they're also, according to the law, asking the planning board, as the law directs, to conduct a study to see whether or not those areas should be designated as in need of redevelopment or rehabilitation.
But I want to be clear, under law, and like in certain cases, like with the central business district, you know, we had 45 days to act on that, or, you know, they could move ahead otherwise, without waiting for our input. What I'm asking is, statutorily, is there anything which says the planning board has to act within a specific period of time? Meaning, I'll just make this up. Let's say it had to be done within 30 days, our next board meeting will be after 30 days, and if not, it automatically just moves on to the next phase and the study is done. If that's not the case, I have the feeling that members of this board would be more comfortable waiting until August to have appropriate representatives come and just explain and answer some of these questions that we have before we approve this. So my question is literally, are we required to vote on this tonight, or are we not required to vote on this tonight?
My understanding is the board is not required to vote on it immediately.
Okay.
The purpose of the study, what would happen if the board did not vote on it is, the purpose of the vote is to decide whether or not the board is going to conduct the study. Without
Wait a minute.
going forward, how are we going to conduct the
If the
study?
board doesn't.
You need a mic.
Go ahead,
If the board
Susan.
doesn't vote on it, can the Board of Trustees choose to do the study anyway?
They can do the study, but it's still got to come back here. It's still got to come back here.
I have been not involved in all of the discussions with everyone, but there was a definite process by which the Irvington Avenue Committee and the Board of Trustees Subcommittee did determine through a fairly significant discussion as to what made sense, as to what to look at preliminarily, what had the potential of revitalization and redevelopment opportunities, and that's how they looked at various factors such as ownership. Maybe a couple of the properties were owned by the same people. They looked at various things and determined that. And that's why there were properties in between that they made the judgment did not warrant a redevelopment review, and to really focus their energies and everybody's energies and efforts on those areas that had revitalization, redevelopment potential.
But Susan, unless you can speak to those reasons specifically, I think the sense I'm getting from the board is that there is a certain amount of discomfort with the fact that there is something that's sitting in front of us which is not easy to understand or explain why it's being done in the way it's being done. And I understand, I explained why, to my understanding, there aren't people here. You have done a good job of explaining redevelopment versus rehabilitation and what's involved in all that, and you have certainly talked to the fact that there has been, and as I had pointed out also, there has been a group of citizens and elected officials that have been, maybe business owners, what have you, who have been looking into this. And it's not to say they don't have their reasons, but quite frankly, I think the question is why? It's not just that they have their reasons, but why? And that's what I think I'm sensing from my fellow board members.
I would like to add to that. I would just like to say that I'm looking forward to hearing from somebody on the committee about this. I'm excited to hear about what is going on. There's been a lot of work done. I've heard a lot of talk about it, but we're being asked to approve something that I literally have zero information about, other than just asking me to approve more study. I think it's completely reasonable to ask for additional information to get more background on what we're voting on.
That's why I asked the question about whether there's a statutory reason. If there's a statutory reason, we're going to vote tonight, even if the vote is no. But since we're being told that there is no statutory requirement that we act tonight, I'm going to wait for somebody, not me, to make to make a motion. But if there was a motion to table this, I wouldn't be surprised if it got the support. Can I, before you do that, I just want to clarify one. What a surprise! I want to clarify though that I think that the last resolution, with number 197 on the third page of your agenda, which deals with rehabilitation, I believe that could stand on its own potentially. This is not where you're looking at this map and trying to figure out. This is dealing with the entire township, and we can put everything off. I just want to mention that at a minimum, that resolution is different. The other thing before we vote on tabling. I know that there are at least, well, I think I can see two people in the audience who might have come specifically, members of the public, who might have come specifically because these matters were going to be dealt with. And while I suspect I get a sense of where we're headed with this, I do not want these people to have wasted their time, that they've come out. And so I would like to ask the indulgence of this board that if there are members of the public who wish to come up and speak on these matters, that they're more than welcome to do so. Certainly not required, but welcome. And if you could just identify yourself and address and so forth. Oh. Is that microphone working? It doesn't. I don't hear it. Is that microphone working? Yes? Okay.
Good evening, Janine Bauer, 416 Clark Street. It's never a waste of time to hear this august body debate, tabling an important set of resolutions, 9, I think if I counted right, on redevelopment, and 1 on rehabilitation. I think in the direction you're going is exactly what my recommendation would have been, to table it and hold off. I'm not keen on the idea of having such an important decision going forward with this study made in August, but there's really not a lot that can be done about the schedule. I was going to address you about what the criteria is. I definitely do not think that, I feel that the selection process was arbitrary, and I do not think that there are a lot of lots selected in these blocks that meet the criteria, but I sense that that's for another time, and I certainly don't want to waste anyone's time because I know how hard you all work and how late you all stay.
Thanks, Janine.
Thank you.
Thanks, Janine.
This is not the time to talk about criteria.
Good evening. I'm James Johnston. I live at 266 Irvington Avenue. If you look at your little, you see the 3 long lots. One of them is mine. I can ask how long each of you have lived here. My family will have owned that property for 95 years this October. I consider it my home. I find it very upsetting. Excuse me?
I'm sorry to interrupt you, Mr. Johnson. What was the address of the property?
266 Irvington Avenue.
And it's one of the lots,
The long ones.
one of the
You know, where
contiguous.
you
It's
just
number
have
6.
those and
In
nothing
number
next
6.
to it.
Yeah.
Yeah.
I did go to some of those committee meetings, and I did ask, well, why aren't you studying it all? And the comeback was basically, well, why have people who might get involved in a lawsuit who we're not going to take? I think it's very sad, another point, that the property owners affected are not notified, even at this process. Since the statute did change, this could have been done without condemnation. Am I correct?
Oh, you're absolutely correct, and that was a
So,
decision the Board of Trustees
Exactly.
made.
And I have dealt with you before on the other Irvington Avenue committee, and I always give you respect, and I always told people when, the 3 long lots where I am, and you just said, they didn't like your answer. You said, if you can't get a developer to buy 3 properties, you shouldn't deal with them. And since you were on the planning board, do you know what my property is zoned for?
What it's zoned
It goes
for?
back 440 feet deep.
It's all 3 of those?
All
long lots?
3 of those lots go back 400. They're only 50 feet wide, but they go back 400.
Are you the owner of all 3, Mr. Johnson?
No, I'm the
Just-
owner of 1.
Okay.
So together combined, they're over 1.5 acres. But do you know what they're zoned for?
Not offhand.
Nothing.
Okay.
So after all these years, you see viable property that is split zoned. Why has the planning board, we had a $300,000 or more study, which made sense. He said, the Cecil Group, that property should be zoned so a developer can buy it and know what he can do with it without going with the neighbors and all of that. Why has it not been done? Where do you find that much property in this town? And that it's not zoned for anything looks to me, after all these years, it was deliberate that it has never been zoned as being viable. So I do feel those properties can be zoned. I said years ago, From, Ms. Gruhl, from Prospect to Titchener, what is it zoned for? Isn't it multi-housing, but housing can exist, so on and so forth? And I said years ago, well, why don't you zone from Titchener to West Fairview the same? The town refused to do it. If it had done it, I'm assuming where I am, you could put up apartments or multi-housing without someone having to, without redevelopment. Redevelopment, the idea of a 30-year tax abatement, you know no one wants that anymore in this town. I'll never believe anyone wants to take somebody's home. And I'm shocked that affected property owners are not advised, even at this process, because when they, my understanding, and I could be wrong, is that you just have 45 days after you receive notice to act or you lose your rights. That's one hell of a letter to get. I've lived here all my life. My family's owned it for almost 100 years. That I would receive a letter from my town that you could take my home is very sad. And I think you have other ways to do it.
Can I ask you, of the 3 long lots, yours, which one would yours be? The one closest to the downtown? Closest to
My
Titchener.
neighbors are in Titchener. And I have 2 houses, even though they don't know there's another one.
We won't tell anyone.
I pay 3 sewer charges.
Thank you.
Okay, thank you. Is there anyone else from the public who wishes to be heard? Okay, we're going to close down the public part of the meeting, and I'm happy to entertain further discussion or motions
I
to deal
move
with.
the table.
Okay, so you are moving to table all resolutions?
All resolutions, because one
Okay.
of them that you mentioned also deals with sewer, and there's information missing on
Okay.
that. Okay, whatever, I
So-
move the table all of them.
Okay, is there a second? Second. Okay, second from Reverend Wilson, okay. Do we need to vote on these individually, or can we vote on these collectively, council?
I believe we could vote on them collectively, Mr. Chairman.
Okay. Jetta, will you call the roll, please?
Mr. Chairman?
Yes.
I would just comment that if there's someone who wants to vote differently on one of them, we should know about that ahead of time.
Okay, so let me pose the question to the board. Is there anybody who feels that they're going to vote differently on any one of them, so that we might want to split this up? Okay, so that's a good point. But we'll proceed with the vote on all of them then. Jetta, whenever you're ready.
Okay, Mr. Colton Max,
Yes.
Mr. Miller,
Yes.
Reverend Wilson.
Yes.
Mr. Allen.
Yes.
Mr. Chambers,
Yes.
Mr. Lerman.
Yes.
And Ms. Harris.
Yes.
Okay. How will this information be conveyed formally? What would be the best way of doing that? Jetta, Jetta, can you please inform,
Yeah, can we make a motion to have someone present the rationale to us?
we don't need, I'm not sure we need, I would agree with the idea. I don't think we need a motion, but I think that we should be asking for representatives from this body.
Mr. Chairman, if you like, I'll prepare a letter.
Okay.
I would make a better suggestion, a personal phone call from the chairman to the president of the board, just to say, hey, it was turned down, it was tabled, we really need somebody that was on the committee to come and present it and discuss it.
Okay.
And
Can we also
I
learn more,
think it would be a little bit more homey.
sorry, can we also learn more about the notification process?
Sure.
Timeframe?
Sure.
Can I add to that? I'm curious if this board has the right, the ability, whatever, as this gentleman suggested, to in fact notify all these people that we're discussing this. Because if we do have that ability.
For the public hearing, they have to receive notice.
Yeah, and that was a bit
No, that
off.
wasn't the
That's
question.
not what he's asking.
Do we have the right to mandate notification to all of the property owners who are on this, whose property is on this piece of paper, of our process, including that we are discussing this in August? I just don't know the answer to the question.
Process is, statutory, so whatever it is how it's going to lay out.
I would suggest that each one of us is a private citizen and can act as he or she sees fit outside the confines of this room. But the planning board itself, I don't know if it can do that thing specifically, so you can you can certainly do whatever you think is most appropriate as an individual citizen of South Orange. Could I ask also, Susan, although you were very eloquent in describing it tonight, could you please, if you wouldn't mind providing this board with a primer, something, it doesn't have to be very long, but something that lays out what redevelopment, what it means to be designated as an area in need of redevelopment, what it means to be designated as an area in need of rehabilitation.
I would be happy to, and I should have thought of this before. I gave it to the Board of Trustees. My partner and I have written 2 articles recently. One is in the Environmental Law Journal, and the other is an NJPO article on the redevelopment process and the rehab process. The only thing it doesn't have in, but I can add a little bit, is on the latest law change. But it does go through everything in terms of process, in terms of substance, which you would have when we do the study anyway, because that would have to be laid out. But I'd be happy to email that to everybody so you have it.
Great. I think that would be very beneficial. Could you also clarify, when I look at block and lot numbers, I mean, I can barely remember my own block and lot number, so I can't make heads or tails of which area is which. Can somebody identify the actual property addresses that are included in this as well?
Well, we will. We haven't done that yet, but we would do that, and we'll be happy to do that now if you direct us to.
Would you? I mean,
Sure.
I think we would appreciate it if we knew more specifically. Just one other question, I don't know who to direct this to, but I find it very odd that this area number 9 is literally the property we voted on approving a application this evening. If an area is in need of redevelopment, then you wouldn't have an applicant coming before the board with a plan that the planning board would approve.
Well,
it seems to turn it on its head.
I would just note one thing, and I'm not arguing the merits of that, but I will say that there is only one criteria that requires a statement that it is cannot be developed under the instrumentality of private capital. And that is under C, which is not the standard that when you get into that. So all the other criteria do not are development neutral as it comes to whether there is an application. As a matter of fact, one of the key cases was the Levin case in the Supreme Court, New Jersey Supreme Court, on what is now the Bridgewater Commons. At that point in time, that was designated under the E criterion, and Levin, the 2 guys from Harrison, the old 2 guys, had control over, had control over at least half of the property and stated in court that they were going to redevelop it, and they had redevelopment plans and such. The New Jersey Supreme Court, under the redevelopment law and under that case, really stated that didn't go to whether it was should be and met the criteria designated as a designated redevelopment area.
Okay.
That's my planning, just a comment, okay?
Fair enough. I think there's a question which I know I'm going to ask when we get to
I understand the question, but I just wanted to clarify that.
I understand. Yes, sir.
Just a further comment. We're now going through, or soon to embark on a master plan review. Ms. Gruhl, isn't our master plan going to take into consideration certain areas and what might be done with them or suggested to be done with them? What effect does the review of the Irvington Avenue corridor have on the...
It would be coordinated, but it wouldn't be out of sync necessarily.
But wouldn't that come into also play? Couldn't you accomplish 2 birds with 1 stone?
No,
By doing the master plan at the same time? No.
not necessarily, not necessarily. It's a
Okay.
different process. It's, again, has to
Can
be
it-
coordinated. but-
Under a master planning process, can areas be deemed in need of redevelopment?
No.
So you
Okay, that
can't,
answered
you
my
can't.
question.
Yeah. Okay. So we have.
But you can probably issue the RFPs at the same time, correct? You can-
No.
She's already
You
had
have to
the,
separate
she's already been approved.
Oh.
I guess they already did the
So, okay, so we've now dealt with this matter, we voted on the resolutions, we're going to table them until the August meeting, we're going to be reaching out to get some people to come and provide this board with additional input, and I think that is the last item on our agenda.
One other ad.
I'm sorry?
One ad.
Okay.
The master plan committee met tonight, two of us along with our planner. And there were a couple of questions that were asked that I don't have the answers at. It's my understanding, and I have a copy of it now, that I just got this evening, that an RFP is being prepared for a master plan study. It was my understanding that the master plan is under the jurisdiction by statute of the planning board.
That's true.
Okay, wouldn't the planning board prepare that RFP, or would it go, or would the town board prepare that RFP?
Typically, the RFPs for the governing body and the land use boards are prepared centrally.
Okay, wouldn't the planning board be sent a copy of what they're thinking of for its input?
I would think so, although the master plan RFP has been issued by the township previously, and I don't think it's going to change much. It's the basic statutory requirements of what the board, what the master plan has to say.
And if we wanted to add some things to the RFP, I mean, don't you think we would, we should be getting a copy of it to at least critique or to look at or add input?
That is, it's a good question. I don't know why it
Okay.
hasn't been distributed.
Can you
That-
please?
And that was question one that our meeting had tonight. Question two was, do we need an RFP? I mean, we've already engaged a planner for the year. We've engaged that planner to do or when I say we, the township has engaged that planner to do the Irvington Avenue corridor study, assuming it gets approved at some point. Why would we go out with an RFP unless, I don't know if the township board requirements, bylaws or what have you, require it, but why would we be considering taking an RFP and bringing in another firm, possibility? I just don't understand the process.
What the scope is of your contract with the planning board, but would it include master planning?
Yes.
Okay, so.
And so I would ask that somebody direct
Would
that
you-
question
Okay.
also to the town board.
We're directing Patrick to include that.
Okay.
Those two items.
And just, we're going to need another meeting. I mean, we only had two of our members show up, again, circumstances, and I won't go into them. But, I mean, we got some smattering of an idea, but we need another meeting probably next month. Maybe I'll send an email out. But we really, once we get those questions answered, if we can get that done fairly quickly, then I can at least set up another meeting so that we can start addressing what may we want in the review.
Right. Okay.
And I welcome anybody's input on or off the committee on the master plan. Since I have not been through a master plan from scratch, I've been through the review or the update, but it's not literally doing one from scratch. So I welcome any input anybody wants to give,
Okay.
including Ms. Bauer.
Let it be noted for the record that she saluted from the audience. All right.
Can we make a motion to close?
We could make a motion to adjourn. Would you like to make one?
Yes.
Motion to adjourn. Second. All in favor, say aye.
Aye.
All opposed, the ayes have it. Meeting adjourned.
What's your back?